Welcome to Office Hours, where we take listener submissions and stories, and Lindsay asks me them, and then I see what kind of answer I can come up with. Lindsay, what's on the docket today?
Yeah, we're going to get into some law firm operations questions today. So, our first question today comes from an attorney in Phoenix, Arizona, who also does family law. He says, John, I was very impressed with your Clio presentation yesterday and wondered if it would be as easy as me just asking you, where do I start? Since your firm and mine do the same thing, I'm grateful for any advice. I've been doing nothing but family law since 1992. I started my firm in 2005. I wonder if it's worth making such a big change when I probably am only going to be doing this for another 7 to 10 years. I have a good system that I've refined in my years with Outlook, time slips, WordPerfect, and Word, but I'm getting pressure from my younger associate attorneys to incorporate Clio or Smokeball or something similar. I also wouldn't mind increasing my revenue for the years that I have left. That's for sure. I don't want to resist just to be a dinosaur, but I also, which is something we respect in the legal profession, but I also wonder if making some sort of change might increase the value of my practice when it becomes ready to sell in a few years. So it comes down to how can we get away from the billable hour? I'm convinced that you're doing exactly what I do, and I don't see how we could not get away from the billable hour in family law. So is it as easy as me just asking you, where did you start?
Wow, that's a fantastic question. I'm
Yes.
sensing a couple of different parts of it. One, I want to be very clear that just because you've only got a couple of years left in the profession doesn't mean you can't make tremendous progress. Hemmat Law only 2 years ago was 2 people, myself included. I was half of its workforce. Now there's over 20 of us just in our litigation department. We've got a podcast. We've got a couple of different media projects going on. And that all happened in the last 2.5 years. So there's a tremendous amount of runway in front of you, I want to make clear. Second off, you're in a better position than most because I'm hearing a gentleman.
Yes.
The gentleman has associates who are engaged, who are pushing for change.
Mm-hmm.
I really want to encourage that as a blessing, right? Having team members who are invested enough in your business to give a shit, frankly, is something that most people do not have. I think I'll leave off by saying Hemmat Law does things for the benefit of its team members. You should never make management decisions based on what leadership prefers and not what's most useful and desired by the vast majority of the rank and file of what you're working with. I infer this law firm is about 2 to 7 people, I'm guessing, because there seem to be at least a couple of associates, probably 1 or 2 office managers or something similar. That's the fantastic sweet spot because you're agile enough to change quickly, but with enough capital, presumably, and revenue that you can really make some financial investments to really boost your business. In terms of increasing revenue, I always recommend Clio. It's the market leader. They've got 3 times the user base of the next couple of competitors combined.
Oh.
Yeah, right? Exactly.
That's a lot.
It's for a reason. They're not perfect. We use them, and I don't think they're perfect, but I think they're, for the bang for the buck, they're the best exchange.
Mm-hmm.
And the reason this matters is when you're looking for acquisition, there's 2 nexuses of the value of a law firm. It's the net present value of its future cash flows, which that's a talk for another time. It's the value of the future revenue it represents, and then it's also how easy it is to acquire, manage, and fold into your current business because someone's acquiring this, right? If you have a system of time slips, WordPerfect, shout out WordPerfect to the OGs. If you have time slips, Office 365, some sort of cobbled together, maybe effective, but cobbled together custom system, no one else is going to be able to use that. And so the transition cost of acquiring that business will be factored into the purchase price. Switching to a well-known operating platform, even if it doesn't improve efficiency at all, will make your business more valuable by default. That was a fantastic question. I would love to hear more from this person. Contact us at gossipwithoutprejudice@gmail.com. I hope my answer was helpful and instructive. And, yeah.
Hey guys, I have a personal favor to ask. It would mean the world to me if you could share the podcast, leave a review, or tell a friend about our work. We are on a mission to make the legal industry more accessible for everyone. If you want to support the podcast, go to gossipwithoutprejudice.com. A monthly pledge as low as $5 keeps our work free forever for everyone. Thanks. Are you ready for our second question for today, John?
Lay it on me.
Beautiful. Our Attorney from Montana says here, "Good afternoon, John. I attended the Clio AI presentation yesterday and saw you speak. You said something to the effect of, what I would really do if I had the chance is start a personal injury firm and leverage attorneys with AI instead of paralegals. Well, I have a PR firm with a lot of cases and too many paralegals. What can you recommend to try to implement such a strategy?"
You know what? This is really interesting because for those of you that don't know, personal injury firms are triangle shaped, right? They have a relatively small number of attorneys at the very top, and then usually a fuck ton of various staff members. A lot of PI work is very routine. It's very ordinary and repeated. So like managing the client, checking in on current health status, getting records from various third parties, conducting and coordinating investigations with experts. And then the attorneys, all they really do is they sign the demand letters prepared by their staff and then send them out the door. And that's why you see personal injury like Dubin Law here in Seattle, Washington.
Yes.
I think there's like 50 people that work at that firm, but only I think like 7 attorneys.
Wow.
Yeah, exactly. And that's because you don't need a law degree to do most of the PI work, right? It's just cheaper to hire people without, to shepherd that paperwork back and forth. And what this gentleman is referencing is a comment I made saying, hey, we do family law, but if I had to start over again, AI has the greatest capacity to take over routine, common, repeated, predictable work. Family law is none of those things, so it's really tough for us to get away from the billable hour, really tough for us to implement AI in the ways that are most maximally efficient. But what this gentleman is rightly pointing out is that there's tremendous opportunity, particularly for plaintiffs injury firms, to go in and really hollow out that massive drag on their balance sheet, and hopefully do not fire those people, but pivot them into other useful functions with the use of AI. My answer to that is fantastic stuff. I am far too late to start over again. I like Hemmat Law. I love family law and what we do here. But I would recommend talking with a consulting agency as quickly as possible, anyone listening right now, and learning how to use AI as quickly as they can. The lawyers will not be replaced by AI, but they will be replaced by the lawyers who do. That, and also there's another issue. I think too many paralegals and legal assistants are not reliably sourced and standardized. Like there's no standards for what a paralegal is. There's no standards for what a legal assistant is. It's part of why it's so hard to hire them, because you don't know the true competency of the person you're bringing on board, because they may have the same job title at the last firm, but they may not do any drafting, and they have to do drafting here. And AI has a tremendous market cap opportunity to a huge growth in the legal industry, particularly for early adopters. Where to start? I would say it depends on the technological feasibility of the firm. If they have the capital to invest in a custom closed language model, which is to say an LLM that you host on an internal server that does not interface with the internet, so there's no privacy concerns. Listen to that last part. Last part is important. Additionally, there are some enterprise API connections that do have some privacy options with ChatGPT, which I know is like a weird taboo thing to say. ChatGPT and OpenAI do have custom enterprise options that do not train their data on what your inputs are. We do not use ChatGPT, though it is an option. We use the Microsoft Azure ecosystem, which, if you did not know, Microsoft owns a substantial part of OpenAI. So Microsoft's LLM is virtually just ChatGPT, but free. Because they already have so much overlap. Most people don't know that. It's just different branding. So we use Azure. It's a fantastic resource. Talk to your team. Talk to somebody knowledgeable. We're not taking any contracts right now for our consulting department. My apologies, but thanks so much for the question.
Yeah, thank you so much, folks. Is there anything else that you want to touch on today for legal operations?
I think if there's tremendous opportunity in one thing, I think it's unorthodox branding, social media. We want to get into this more often later, but if there's one wild card I want to touch on, hire someone in your firm to just get out on the street and get on TikTok, get on Instagram, get on the airwaves like we are here. Social media is both durable and dynamic, which is to say every podcast we put up, that stays there forever for a theoretically infinite audience. And the adaptability is backwards looking. So if we go on to grow this podcast 5 years from now and we have 10 million, inevitably, which we will, 10 million subscribers, then all the stuff we're doing today can be viewed by them. It's durable. Or if you grow your audience literally anywhere else on the internet, you can link all your social media projects together. Get out there, get get your firm a personality, I think it'll pay dividends.
I've been seeing on TikTok what Hemmat Law has been doing with social media, and honestly, it's kind of mind blowing.
Well, for those of you in the audience who don't know, we have a social media account called Law on the Street. We go and we interview people in Seattle. It's very Humans of New York sort of thing.
Yeah.
Our twist is that we cancel not student loan debt. We cancel medical debt for Washington families. So we cancel usually $10,000 per interview subject. We did $100,000 for our inaugural subject, which was a lot of fun. Since January 22nd, when we started, it is now March 7th. I think we've canceled close to $600,000 in medical debt.
Wow.
That is an extreme example. We have the resources to launch that sort of endeavor, but you don't have to go anywhere near as big for people to know you. Lindsey, thank you so much for the questions. Thank you so much for our submissions this week. We are now wrapping up office hours with LTBE, Lindsey Takes the Bar Exam, where we ask a non-attorney and non-legal professional bar exam questions and see what happens.
Yep.
Lindsey, are you ready for your first question this week?
I am ready to give it my best shot.
Okay, perfect. So the last questions last week were very procedural.
Yes.
Malice aforethought, by the way, just means premeditated. So I really hated that legal nomenclature. But this week, a jury in federal district court concluded that the defendant had infringed the plaintiff's patent. The jury completed a special verdict form that listed each of the defendant's 3 accused products by model number and indicated that each model number infringed the plaintiff's patent. The district court entered final judgment, awarding the plaintiff monetary damages and an injunction that barred the defendant from manufacturing the infringing products. The order entering final judgment listed the defendant's accused products by their respective model numbers. In reviewing the order during briefing on the parties' post-verdict motions, the district court clerk noticed that one of the listed model numbers was incorrect. Neither party had yet filed a notice of appeal. The question is, may the district court correct the error in final judgment?
This is, again, I have zero knowledge. I have nothing to go off of here, but it's interesting. So my first thought is that, yes, the court should absolutely be able to appeal something if they know for a fact that it's a mistake. However, what are my multiple choice answers,
Your
please?
multiple choice options are A, yes, because the error is clerical. B, yes, because the district court may correct errors in the record at any time without consent from the parties or any reviewing court. C, no, because a court requires a motion from a party to correct an error in the record. D, no, because the district court requires permission from the regional circuit appellate court before it may correct the record.
Interesting. Okay, so I'm leaning towards A or C there. Can you read me A and C one more time, please?
A, yes, because the error is clerical. C, no, because a court requires a motion from a party to correct an error on the record.
Okay, I could really see this one going either way as someone who knows nothing about patent law or in appeals courts. But the interesting part to me here is the clerical specification. Whether or not a typo is a clerical mistake that can just be corrected. I would assume yes. However, when it comes to model numbers, that's something that's so specific. I'm thinking maybe the court doesn't necessarily have the purview to decide whether or not that's a clerical error. Oh goodness, I'm not sure which one to pick. Is there anything else that you have to add before I choose my answer?
The only thing I would add is take note of the language. Neither party has yet filed a notice of appeal.
Neither party has yet filed a notice of appeal. So neither party has noticed that this is incorrect. There's a chance, there is a chance that it's not incorrect, but the question specifically says that is an error, so that's not the case. You know what? I'm feeling more towards C. I think I'm going to lock in my answer as C, that one of the two parties has to file a motion first before the court can amend it.
Locking in C?
Locking in C.
Blake, sound engineer, weigh in. What's your answer?
What do you think?
C.
Yeah, Blake thinks C too.
Locking in C.
Hard.
C is incorrect.
Dang it! Oh, we didn't get it.
I'm sorry. Okay, so we'll start by eliminating the incorrect answers.
Okay.
Answer C is incorrect because a court may correct an error in the record on a motion from a party under Rule 60 or on its own initiative.
Okay, so that's where I was wrong.
It's per Federal Rules of Civil Procedure 60A. Answer B is incorrect because it is overbroad. The piece of information you were not given is that a district court requires permission from an appellate court to amend the record for any reason if an appeal is pending.
Okay.
So answer B is incorrect. Also per Federal Rule Civil Procedure 60A. And this is obvious reason. If there is an appeal pending, then a copy of the record has been sent to an appellate court. And so what you don't want is a record at a lower district court suddenly being amended without the appellate court knowing, and then the appellate court making rulings substantive on the matter.
That would be a mess.
Yeah, that would be a mess. So the solution is just to go to the appellate court and say, hey, can we amend this record, this issue, this clerical record? This was an error of the clerk. And then 99% of the time, appellate court says yes. But by inference, also, I should amend and say answer D is incorrect because the district court only requires the appellate court's permission to correct a clerical mistake on the record after an appeal has been docketed. Same reason. Okay. Answer A is correct because a court does have the power to correct clerical mistakes at any time if no appeal has been filed.
Okay.
And so they have broad discretion per Federal Rule of Civil Procedure 60A and a whole bunch of, case law that says clerical errors are those that fix a mistake on the record so that the record reflects what it has always said.
Okay.
So this was a strict clerical record issue, and so the clerk and the court, I would argue, has the duty to amend.
Yes, I agree that they have the duty to amend that also, but thank goodness that they don't have to go through more bureaucracy just to correct one tiny little mistake. Boy, would that be a hassle. So, I'm glad it's A. I was almost there. I was close.
Yes, better.
It's one of my 50-50s.
The key takeaway here is that appellate courts weigh in only when an appeal, for an amendment of the record is involved in an appeal, right? So if the district court, nothing else is above it, can amend anything it wants on the record in general. Okay. Small exceptions apply, but not worth noting here.
Sure.
Thank you for another week of LTBE. That was Office Hours. Let us know what you think about the new segment format. We'd love to hear your feedback, love to hear your stories, love to hear your questions. Like, share, comment, subscribe. Pledges of as little as $5 supports the show and keeps our work free for everyone forever. Thank you so much for joining us.
Yeah, and thank you for playing LTBE with us. That's my favorite.
Perfect.
Thank you so much.